Sir, I shall deal with the question straightway. So far as permanent or temporary workers are concerned, the provision specifies the period of service and it has been further defined that many days of service constitute continuous service for a year. About what action will be taken against the employer if he fails to implement the provisions of the law. The law has made provision compensation is a legal obligation and it can be enforced. Sir, I have not to add very much to what I said at the outset. I find that the reactions to the proposed legislation proceed from two different and opposite angles, and if I may submit, the two extreme views put forward are based on some kind of misunderstanding or improper understanding of the aims of this legislation and the ends which are sought to be achieved through. They are limited aims. They are twofold aims. Firstly, coming to the views expressed by my honorable friend Dr. Mukherjee, the question was viewed chiefly from the interests of the industry, and from the other side, the question was viewed chiefly from the interests of workers. We have tried to balance both these things, but no claim is being made that through this legislation all that can be claimed on behalf of the industry or on behalf of the workers is going to be achieved, because the two aims are fair deal to the workers and that production should not be curtailed, and also that the industry should not suffer. Now, this legislation also has two aspects. One is the attempt to prevent closures through the deterrent effect of these provisions, that the is good deal of substance in this approach will be evident from the fact that in the first case, when an ordinance was promulgated, a number of closures which had threatened actual did not materialize. This means that something the closures were not really so very necessary, and there were no compelling reasons. There may be some consideration of avoidance of a little loss in time when there is a depression, when one can do without additional production and things like that. The limited interest of a particular individual employer and not the larger national interests concerning production or the interest of the employees may perhaps be consideration. In these cases, this legislation has a solitary effect. It will still have that effect when we pass this law now, but it either the workers or those who are very keen to have no curtailment of production think that this is going to stop closures. It is not so. Other things have to be done in order to prevent closures which are preventable. Some suggestions have been made by my honorable friend here. They are very good suggestions, but they do not directly concern us here. We face to do other things. We have got the Industries Development and Regulation Act, and we can put into use the various provisions of that act also. Something of that kind was done before in the case of one concern to which my honorable there made a reference. I may inform the House that even in the case of the closures which have occurred and regarding which we received information, we started acting. I believe that some inquiries are in progress, and it is quite possible that where this legislation which we are going to pass may not come to our rescue, something else may possibly be done. There are suggestions like standardization of wages, decasualization, etc. And there will be other suggestions also. Why is it that a management, because of its efficiency, because of neglect, allows the concern to run down to that condition that it ceases to have its competitive position in industry? Various things can be considered, but this is not the place for that. Similarly, so far as employees are concerned, something is being done on their behalf. First, if the legislation succeeds in preventing a closures, to that extent unemployment is warded off. To the extent it does not succeed, some relief is afforded to the workers. They get some compensation, but that does not exhaust all that the workers may be able to secure from industry at the time of termination of their service. There may be provisions for gratuity, etc. They are not ruled out, they are not eliminated by these provisions. Therefore, the scope of this legislation does not cover fully either the ground of continued production and of averting unemployment, or in the case of unemployment, of what is going to be done for the employees. So, sir, in that limited context, we have to view the propriety of the various clauses that are being considered here. Regarding some specific points made, it was urged that we have brought this bill at the fag end of the session, and therefore we are not giving, although time for consideration? That is a question which depends upon the confidence of the house.